Resuming debate, the Honourable Parliamentary Secretary to the Minister of Justice and Attorney General of Canada.
Merci, Madame la Présidente. At the outset, I'd like to say that I will be sharing my time with the Honourable Member for Scarborough Southwest. Today, I'm rising to speak against the motion brought forward by the Conservative opposition, and my reasons for doing so are straightforward. Contrary to what this motion suggests, our government has already unequivocally condemned Daesh for committing acts of terrorism and genocide, as they should be. In addition, the Canadian forces, law enforcement, and intelligence communities are fully engaged in combating and preventing terrorism in all its forms, both abroad and at home. This is work we should all be proud of. And finally, Canadians can be confident that we have enacted a robust set of criminal laws, offences, and preventative tools for law enforcement to address terrorism, which are prosecuted to the fullest extent of the law, wherever and whenever appropriate. In a moment, I will expand on how these measures are collectively working to keep Canadians safe. But first, I need to express how regrettable it is to hear the opposition politicize national security time and time again. Far too often, we see the Conservatives wagging their fingers, lecturing Canadians, and pandering fear on this subject. However, one need only look at their record to see that it's heavy on rhetoric and light on substance. And I hear honourable members heckling from the other side. That won't change the facts, Madam Speaker, and let me tell you what some of those facts are. During their 10 years in government, the Conservatives imposed dramatic cuts to national security. Indeed, in their last 4 years in power, they slashed close to $1 billion in resources to the RCMP, CBSA, CSIS, CATSA, and CSE. The opposition would do well to remember these figures, as I know Canadians will, in sizing up the validity of this motion and the credibility of the Conservatives on the whole of national security. Let me now say a few words about a number of the terrorism provisions within the Criminal Code that specifically apply to terrorist travel. And I would like to begin by acknowledging that thousands from around the world have indeed traveled to join terrorist groups, and that this is indeed an important issue which our government is grappling with both domestically and internationally and abroad with all of our partners in the combat against terrorism. Within the law as it exists here in Canada, there are 4 specific offences of leaving Canada or attempting to leave Canada for the purpose of committing specific terrorism offences. In this way, the criminal law addresses the terrorist traveller phenomenon by having the substantive offence crystallized before the person leaves Canada and by applying the same maximum punishment to attempting to leave Canada as well as leaving Canada to commit these offences. Over and above these targeted offences, the Criminal Code includes terrorism provisions that are designed to prevent the carrying out of terrorist activity and have a preventative focus. They are in large part designed to permit law enforcement to intervene and charge someone with a terrorism offence before a terrorist attack can take place. Such offences include knowingly facilitating terrorist activity and knowingly instructing someone to carry out a terrorist activity. A particular example of this can be found in the participation offence, which is under Section 83.18 of the Criminal Code. Terrorist travellers could be and have in fact been prosecuted under the offence of knowingly participating in any activity of a terrorist group for the purpose of enhancing the ability of any terrorist group to carry out a terrorist activity. And I'll pause for a moment to say, Madam Speaker, that in my former career as a federal prosecutor, I have first-hand experience dealing with these provisions. And again, I would draw the attention to the Canadian public that they can take great satisfaction and confidence in knowing that we have a rigorous criminal law enforcement provision. I was honoured to serve with many prosecutors and members of the RCMP and CSIS who continue to do a good job today in keeping this country safe. As well, it is notable in the current threat environment that individuals are often radicalized to violence and encouraged through online interactions and messaging. In Bill C-59, the National Security Act 2017, the government proposes to revise the offence of advocating or promoting the commission of terrorism offences in general to be one of the counselling the commission of a terrorism offence, whether or not a terrorism offence is committed and whether or not a specific terrorism offence is counselled. The advocacy or promotion offence, which has been much criticised since its enactment in 2015 for being vague or overbroad. Bill C-59 proposes to revise this offence to use well-known criminal law concepts and principles and to facilitate its prosecution. The bill continues to support the view that the active encouragement of others to commit terrorism offences, even without being specific as to which terrorism offence is being encouraged, should be an offence in the same way as it is an offence to counsel a specific terrorism offence. Some of these criminal offence provisions have already been successfully used in court. To date, there have been 26 terrorism convictions in Canada, and 3 trials are currently in progress. Madame la Présidente, permettez-moi d'aborder maintenant la matière qui concerne les outils préventifs d'application de la loi. Certainly one of the most fundamental tools police and prosecutors have to keep Canadians safe from individuals who may have associated with terrorism groups abroad is the terrorism peace bond. This is a powerful preventative tool that can help to protect Canadians from terrorism offences. In situations where police may not have enough evidence to justify charging a person with a terrorism offence, the terrorism peace bond is available to bring the individual before a judge rather than wait until it is too late. In such cases, the court has the power to impose, quote, any reasonable conditions to counter the threat posed by the individual concerned. Il était également prévu dans le Code criminel que le juge doit décider s'il est souhaitable pour empêcher qu'une activité terroriste ne soit entreprise d'intimer à la personne de déposer de la manière précisée dans l'engagement tout passeport ou autre document de voyage établi à son nom qui est en sa possession ou en son contrôle et dans l'affirmative, il doit assortir l'engagement d'une condition à cet effet et y prévoir la période d'application de celle-ci. De plus, le juge doit décider s'il est souhaitable pour empêcher qu'une activité terroriste ne soit entreprise d'intimer à la personne de rester dans une région désignée, sauf permission écrite qu'il pourrait lui accorder ou qu'un individu qu'il désigne pourrait lui accorder, et dans l'affirmative, il doit assortir l'engagement d'une condition à cet effet et prévoir la période d'application de celle-ci. De plus, si le juge n'assortit pas l'ordonnance de ces conditions prévues, il est tenu d'en donner les motifs qui sont consignés au dossier de l'instance. Pour ce qui concerne l'engagement de ne pas troubler l'ordre public lié au terrorisme, cet outil a été utilisé par les organismes d'application de la loi et par les procureurs de la Couronne. Et c'est un outil qui a été utilisé plus fréquemment depuis 2015. Plus concrètement, il y a eu 19 demandes relatives au recours à cet engagement pendant les 2 dernières années, en comparaison à 6 demandes de 2001 à 2014. I would note that during the 2016 national security consultation, some called into question the threshold for a terrorism peace bond that was enacted in 2015 by former Bill C-51. That act lowered the threshold of the terrorism peace bond from, quote, will commit to, quote, may commit. After careful consideration, the government has determined that the lowered threshold is a balanced approach between the constitutional rights of Canadians and the need to protect the security of Canadians. This threshold has also been upheld as constitutional in the recent Manitoba case of Regina and Driver in 2016. Another preventative tool is the recognizance with conditions, which is available for law enforcement in the appropriate case to disrupt nascent terrorist activity. The Canadian passport order contemplates that passports can be denied or revoked in certain instances of criminality and where necessary to prevent the commission of a terrorism offence or for the national security of Canada or a foreign country or state. As you can see, Madam Speaker, Canada already has a broad range of offences and tools to assist in the fight against terrorism. And as the Honourable Minister of Public Safety just said, we need them all and we use them all. In closing, the opposition have spent the last week criticizing national security, national defence, and deriding effective counter-radicalization measures which go a long way towards both combating and preventing terrorism. What we need instead of that kind of partisanship, Madam Speaker, is a thoughtful debate which will strike the right balance between protecting Canadians as well as their charter rights. I encourage all honourable members in this House to reject the opposition motion and to support the important measures which this government are taking on this important file. Thank you, Madam Speaker.
Questions and comments? Questions et commentaires. The honourable member for Barrie-Innisfil.
Thank you, Madam Speaker. Always when my honourable colleague gets up and, as I like to say, defend the indefensible. You know, he just said that the opposition has been up here all week criticizing national security. We're not criticizing national security, Madam Speaker. What we are criticizing is the Liberal attempt of reintegration of terrorists whose intent, its sole intent, is to act on an ideology that kills anybody that doesn't agree with that ideology. So it's not an issue for us as a matter of national security, but I asked the honourable member the same question that I asked the Minister of Public Safety, which he refused to answer. Will he agree with me that this reintegration process is nothing but a crazy gesture on the part of the Liberals to think that somehow these terrorists are actually going to reintegrate back into society? It's just into Canadian society. It's just nuts, Madam Speaker.
The Honourable Parliamentary Secretary to the Minister of Justice.
The problem with my honourable colleague's question is in its premise. The premise is that this government doesn't prosecute terrorist activity. Of course we do. And I made mention of a number of very concrete examples where this government has taken very concrete measures to ensure that we keep Canadians safe by applying the criminal law, and we will continue to do so. But what I mean when I say when the opposition, the Conservative opposition in particular, stands up to denigrate the work of the national security apparatus and role players is when we have those individuals who are capable of reintegration, Madam Speaker. And my honourable colleague well knows that there are individuals who we can stop before they go too far down the path of counter-radicalization. We should bring them back so that they can be positive contributors members of society. That is not work that is futile. It's important work, and he knows it.
Questions and comments? The honourable member for Kootenay-Columbia.
Thank you, Madam Speaker. This morning I received an email from a member from Kootenay-Columbia in my riding, and she says, as the wife of an RCMP officer who lives and works in your riding, I was quite alarmed by the December 1st article in the Ottawa Life magazine. It's titled, Minister and Members of Parliament are Failing the RCMP and Canadians, written by Carleton criminology professor Darrell Davies. I know in my riding of Kootenay-Columbia I've met with a number of members of the RCMP over the last year, and they will tell you that they are underfunded, understaffed, working with poor equipment. New recruits, I spoke with a new recruit who just came out of Regina within the 6-month mandatory period after attending boot camp. They left and they went to municipal police forces, provincial police forces, who are better paid, better benefits. And so I'd like to ask the member, first of all, whether he would commit through you, Madam Speaker, to actually meeting with members of the RCMP in his riding, and I would challenge all members in this House to sit and meet with members of the RCMP in their riding, because what we need is a well-funded, well-equipped force to deal with crime and terrorism in Canada, and that is an issue I think that every member of Parliament should be concerned about.
The Honourable Parliamentary Secretary to the Minister of Justice.
Well, I want to thank the honourable colleague for his question. And of course, the Minister of Public Safety routinely meets with members of the RCMP to ensure that they have all of the resources that are necessary to both prevent and prosecute national security matters. But, you know, just to point out what I said in my remarks, under the last government, the Conservatives cut close to $1 billion in resources and important monies which would go to the RCMP, to CSIS, to the CSE, to all important branches within the national security apparatus, which of course had the potential risk of compromising Canadian security. So it's very important that we point that out to members of the Canadian public so that they use that in sizing up the credibility of this opposition motion. Judge them on their actions, not their words, Madam Speaker.
Resuming debate, the reprise de débat, the Honourable Parliamentary Secretary to the Minister of Justice and the Minister